Good morning, good afternoon, and good evening. I'm Professor Paul Daly, University Research Chair in Administrative Law and Governance at the University of Ottawa. And thank you for joining this latest session in the 2024 Administrative Law and Governance Colloquium on the theme of executive power. Executive power has been the site of passionate debate in liberal democracies for many centuries. In recent decades, authority is concentrated in the hands of presidents and prime ministers, with voters increasingly looking to these office holders to give effect to their policy preferences. Questions about the scope of authority and accountability of presidents, prime ministers, and other executive officers have therefore become even more pressing. What powers does and should the executive have? Against which standards should these office holders be judged? And who should do the judging? In this year's series, we will examine the role of constitutional text and tradition, other governmental institutions, and civil society in granting and constraining executive authority, setting standards, and holding the executive to account. Very pleased today to be joined by Professor Peter Shane, who has developed over the course of his career deep expertise in public law, especially pertaining to presidential powers in the United States, working both in the federal government and as a scholar. He's published 9 books, notably today's discussion topic, Democracy's Chief Executive, Interpreting the Constitution and Defining the Future of the Presidency, published in 2022 by the University of California Press. Peter received his JD from Yale and graduated from Harvard in social studies, currently an adjunct professor at the NYU Faculty of Law in New York, where he teaches on constitutional administrative democracy and presidential law. He's previously taught at Ohio State University, where he received the Distinguished Scholar Award in 2011, the University of Iowa, and served as Dean at the University of Pittsburgh School of Law. To each of these positions, he's brought his practical perspective developed in the federal sector, where he was attorney advisor for the U.S. Department of Justice Office of Legal Counsel and assistant general counsel in the Office of Management and Budget. You're very welcome, Professor Shane. And the idea is that you'll give us a 15-minute overview, 15-minute or so overview of your fascinating recent book. And after that, you and I will have a discussion. I have some questions, and those of you in the audience who have questions can just pop them in the Q&A, and Professor Shane will respond, and we can have hopefully a lively and illuminating conversation. So, Professor Shane, over to you.
Thank you so much, and thank you for the generous introduction. I do want to warn the audience, as I mentioned to you before we started, that I seem to have the cough that lingers after whatever head cold has been going around the city of New York for the last 6 weeks. I feel fine, but occasionally if I hit mute with it's like an anxious motion, it's only to spare the recording of my cough. But I'm hopeful that I have sufficient liquids next to me to keep me adequately lubricated for our 90 minutes together. And of course, these topics do mean a great deal to me, and it really is a privilege to talk to you about them. I'm sorry I can't do it in person in Ottawa. That would be fun someday as well. The book that you mentioned, in a way, I'm always a little embarrassed to talk about it, because when I talk to students about argumentative strategy, I always say it's important to focus on the one point that you really want people to remember, particularly in an oral argument, and just keep coming back to that one argument. And this book makes 3 arguments, at least sort of 3 big arguments. So I'm going to try to sell them all, which is, and then very ambitious. One is an argument about how the founding generation understood executive power. Another is an argument about the superiority of what I've called adaptivist or pragmatic constitutional interpretation over so-called originalism. And of course, in the US context, we're talking about interpreting a written constitution. And this is an argument about constitutional interpretation, not just as applied to questions of executive power, but more generally. And then the third is an argument that a particular theory of the constitutional presidency, which has come to be known as unitary executive theory, a theory that took off in the 1980s and has been embraced by the Roberts Court, not only fails to be persuasive on its own terms, but has lent support to what I've characterized as a dangerously authoritarian view of presidential power. It has undergirded what the book refers to as an organizational psychology of presidential entitlement that has been used by some presidents more than others, to be sure, but it's been used too often to resist meaningful presidential accountability, either in judicial settings or to Congress. So the first argument about the founding generation asserts that the founding generation simply did not regard the vesting of executive power in Article 2 of our Constitution as guaranteeing the president, as our chief executive, full, total, comprehensive personal control over execution of the laws by each and every member of the executive establishment. The unitary executive theory is really an argument that the vesting clause, depending on who's arguing, it's either the vesting clause or the requirement that the president take care that the laws be faithfully executed, or the two of them together somehow guarantee the president basically the authority to direct the exercise of any legal discretion that has been vested in the executive branch, either by the Constitution or, more importantly, by statute. So if Congress tells the Environmental Protection Agency to do something, then whatever discretion it exercises is really subject to presidential control, and he can fire anyone who, any officer of the United States who refuses to do his bidding. Now, if you ask, to ask the question, what did the framer on the street think of the tenure protection for the Federal Communications Commission? That's clearly an anachronistic question, but a question that is not anachronistic, and which also goes to a kind of paradigm case that the Unitarians feel strongly about, is to ask what the founding generation thought about criminal prosecution. They were aware of criminal prosecution. They did have prosecutors. They had attorneys general. They had state attorneys. U.S. attorneys originally were called district attorneys. So they had all of these sort of law enforcement folk. And the argument I make in the book, very briefly, is the attorneys general and government attorneys in general were seen in the late 18th century as a kind of hybrid of a judicial and executive officer. They were not considered purely executive officers. Indeed, the Attorney General of the United States is an office created by the Judiciary Act of 1789. It's not a departmental organization act. And state constitutions that mentioned attorneys general typically included that office in the same breath as they were talking about judges and other judicial officers. So, and I go on to point out that some states even continue to have their state attorneys appointed by courts, not by the chief executive. So, this is obviously making a long story very short, but the position taken by Unitarians like former Attorney General Bill Barr, for example, that under the Constitution, the president is alone, singly, him or herself, all of the constitutional executive branch, and that this individual cannot be denied complete discretion over how every government official discharges their duties, that just does not accord with the founding view. So that's argument number one. The argument on constitutional interpretation is an argument against originalism, at least originalism in a highly formalist version, and an argument in favor of what I've chosen to call adaptivist interpretation. I take that word from Chief Justice John Marshall, who referred to the Constitution as having been written in a way to adapt to the crises of the future, to endure for ages to come. And, the book offers a normative defense of that view. Originalism, I would argue, is weak in theory and its appeal is supposedly a kind of promise of objectivity that in practice it does not keep. The reason I say it's weak in theory is because the communicative content that ought to count, if we're looking at a set of words that were, written as a legal command at some point, really lies in the expectations that the readers or the listeners to those words would have with regard to their implications when they were voting to ratify the document. These implications depend upon not just the dictionary meaning of the words, but the context in which the words are uttered, and again, the expectations they generate for application. So again, I think I don't think originalism done well leads to unitary executive theory. But let's imagine you have a room full of people in Philadelphia drafting language about the executive branch. Sitting in front of the room is George Washington. He's the president of the convention. Everybody knows he's going to be president. He's going to be the first president. Whatever they do with the presidency, he's going to be the first. His reputation for honor is very widely venerated. And the establishment that the federal government is going to create will be, maybe in a couple of decades, a few thousand people. If they said, George Washington, he should have complete command over every civil officer of the United States, not to mention the military officer, but every civil officer of the United States. What they're thinking about is a government that in 1800 was smaller than the smallest cabinet department in the federal government today. Now, if you look at the civilian workforce of the American population of 2024, you're talking about a civil workforce roughly the size of the entire population of the United States in 1789. And ask yourself, did the words of Article 2 suggest to the people who ratified them that when the government of the United States was as large as the entire country is in 1789, that one person should control the discretionary activity of each and every member of that workforce? It would be like, Jules Verne talking about, living 20 leagues under the sea. This is complete fiction, something that, would not have been anticipated and certainly not deliberated about. And whatever, normative case might exist for adhering to the dictionary definition of those words or the common understanding, putting aside their pragmatic implications, has to be reduced by the fact that the ratifying audience here was so constrained in ways that no contemporary democracy would ever countenance. So whatever expectations were created were expectations about which very few women got to vote, very few people of color got to vote. This is, and indeed, even among the white male population, there were, people with insufficient property to actually be qualified to vote on what this language meant. So, what is the appeal of sort of formalistically trying to figure out what this limited audience thought the words meant in 1789? And if you look at the way, now, having said that, there are scholars who are doing very serious, very thoughtful, very interesting work on trying to figure out what has come to be understood as the original public meaning of these words. And I don't mean to say that, this scholarship, ought to be sneered at in any way. It's important, it's instructive, it's very thoughtful. But that's not what the courts are doing. If you look at originalism as practiced by judges, there is as striking a correspondence between originalist judges' political backgrounds and the way they read the framers as there would be if they said, I'm a Republican, this is how I'm voting. I'm a Democrat, this is how I'm voting. And there are cases in which the departure from actual history is so remarkably amateurish. And I'm talking with all due respect, of our own Supreme Court, that it is just very hard to take the judicial practice of originalism seriously as a practice in objectivity. What I've argued for in the book is a frank version of adaptivist interpretation that I call democratic constitutionalism. At the current moment, I would argue that ambiguities in the application of the words ought to be resolved in favor of a construction that would most strengthen the character of our contemporary inclusive democracy, embracing both its electoral and deliberative components. This is not going to be a determinist, highly formalistic view, but I think it would at least prompt judges to be arguing about the right thing, not, what an officer of the United States should be allowed to do in 2024 should not depend upon what a gauger or a surveyor in 1789 was allowed to do. I'm trying to avoid saying insane, but it strikes me as a very peculiar way of applying a contemporary constitution. So the third argument, so that's the argument on constitutional interpretation. The third argument is that unitary executive theory in particular has evolved into a dangerous point where it licenses a kind of authoritarian psychology within the executive branch that really resists accountability to the other branches of government. Donald Trump quite famously said, there's this thing called Article 2. He says, nobody ever mentions it. He thinks he's invented every phrase that has ever been used. I said, Article 2 means I can do anything that I want. Well, I will say, as incorrect as that is, it's probably not a wholly misleading interpretation of what his lawyers were actually telling him. Now, the biggest institutional development in American public law at the federal level over the last 50 years has been the centralization of regulatory oversight in the White House. It really, it started kind of modestly under Presidents Nixon, Ford. President Carter got a little more ambitious. And then President Reagan, through an executive order, set up a program of, I'm going to say White House regulatory review. It's technically not in the White House, but it's done by an agency that works as part of the executive office of the president, called the Office of Management and Budget. The tasks involved in regulatory oversight are kind of subdelegated to an office at OMB called the Office of Information and Regulatory Affairs. And at the time that President Reagan signed the order, which he did very early in his first administration, it was approved by the Office of Legal Counsel at the Justice Department, 1981, in very cautious terms, that basically they were saying, the president can't order the agencies what to do in terms of substantive outcome, but he can set up an analytic process through which they can better coordinate with one another. And because the Constitution guarantees the president the right to gather the opinions in writing of the heads of departments regarding the duties that they've been assigned by statute, it's not too much of a stretch to say that he can acquire this information basically by requiring cost-benefit analysis that OMB signs off on. Well, again, there's a very detailed version of this, but this has evolved into a situation where OMB, well, there's a lot of agitation over where the real policy making is being done. Is it being done in the agency? Is it being done by OMB? OMB always says it's the agency. But you can see that presidents have begun to assign to OMB and other agencies tasks that seem pretty conspicuously to go beyond the procedural or the analytic into something more substantive. An obvious example is an executive order that President Trump adopted on his day one, that I think President Biden repealed on his day one, which created a process in OMB called regulatory budgeting. Regulatory budgeting is sort of an odd label because what it really allowed OMB to do, what it told OMB to do, was to give each agency a number that would be the total incremental net cost it could add to the administrative burden on the private sector in any year through all of its regulations. However many regulations it issued, it couldn't impose a gross aggregate cost greater than whatever number OMB assigned. There's nothing in the executive order about the methodology for coming up with that number, and you'd be hard-pressed to find any information about how those numbers were generated at OMB. A proposal to do something like this had been rolling around Congress since the 1980s and had never been enacted. And yet, President Trump decided he could do it by executive order. And I guess it was done, although, again, it's been very hard to get information about that. One of the biggest controversies that, again, is kind of sustained by this way of thinking about the unitary executive is an initiative that is known to people following the controversy in the US as the Schedule F controversy. A few weeks before the election in 2020, Trump issued an executive order that said to the heads of departments that they were entitled to ask the Office of Personnel Management to take out of what's called our competitive civil service anyone who has any kind of role within the agency to influence policy. These could be lawyers, it could be scientists, it could be economists, it could be statisticians. Anybody in a policy influencing or advising role should be taken out of the competitive service and put into what is called the accepted service. And without getting into a lot of details, that's just the basic idea is agencies would have a much freer hand in who to hire, and the members of the accepted service don't have the same level of protection against being removed. Again, President Biden sort of got rid of this idea. It was never implemented because of the outcome of the election. Biden got rid of this, but so there is a coalition of conservative groups in the United States organized by something called the Heritage Foundation that's put together something they call Project 2025. This is advice that they want to give whoever the next conservative president might be. And a theme running through this very substantial volume of recommendations is bring back Schedule F. And Trump has talked about wanting to turn the civil service basically into an instrument of presidential will. That ambition, that vision, is being fed in part by a very broadly worded statutory authority, but it's statutory authority that unitarian executive folks want to be read against a background understanding that the president has this control anyway, that any limitation on the president's removal of anyone who counts as an officer of the United States is itself unconstitutional. This is, again, I think, a very dangerous tendency. The book ends with a chapter on recommended solutions. I always think of those chapters, every publisher wants this. These chapters typically express an author's hopes and dreams, and I'm happy to talk about some of those, but I think the bottom line is that if we want a presidency that is more democratic, we need to have a political culture that is more democratic and a political economy that is more robustly democratic than the tendency we've seen now to have.
Well, thank you very much, Professor
Sure.
Shane, for that very fair and elegant overview of your excellent book. I can't resist asking. I know I should control myself, but I can't resist following up on your remark when you were talking about the unitary executive theory. And you suggested that it licenses authoritarian psychology in the executive branch. I'd have to say, and one question in the Q&A already touches on this, I have to say, hearing that at this moment in time, looking at what might happen in the election in November and what President Trump has intimated that he would do if elected, it's not exactly reassuring that you have a legal and political culture that could be said to license authoritarian psychology.
Well, it's very worrisome, and I'm certainly at the, if there's a spectrum of anxiety over what a second term might yield, I would be at the high end of anxiety on that spectrum, because first I should say, if you read the Trump executive orders, and you read, for example, Biden executive orders, they set up structures for decision making that on paper could be implemented in a transparent, pluralistic way that would invite a lot of contending voices to participate in decision making. But that's not how every administration operates. And I will say that, and it's hard. We become so polarized that it's hard to make what feel to me to be pretty kind of objectively neutral points about governance and have it not sound like I'm just speaking as a Democrat. But the parties have become so different on this, and it is just true that the Biden administration is operating in a much more transparent way than did the Trump administration, so that structures under the Trump administration, which again on paper might not have sounded all that troubling, just are put in the control of people who don't regard themselves as accountable to others. Now, it is when I speak about partisan politics, I'm not speaking as an expert. I'm just speaking as another, hopefully well-informed citizen. But as a citizen, looking at the Trump campaign, such as it is, he's not running on a specific policy agenda of any kind. I mean, he will just say, he's for this or against this, depending on what the headlines of the week are. So right now, you may be aware that a state Supreme Court in the United States interpreted a wrongful death statute in the state as allowing punitive damages to be awarded against a fertility clinic whose actions had resulted in the non-viability of certain frozen embryos. The frozen embryos were, in the words of the court, were considered extrauterine children. And this has caused an enormous controversy, as you can imagine, in the world of reproductive rights. And so, Trump will say at a rally, I support IVF, I support in vitro fertilization. But you won't find anything on his website or anything he ever says that speaks in detail to any of that. The only thing we know in detail is what he intends to do, or what he hopes to achieve in terms of eliminating from the civil service any opposition to his pursuing whatever he regards as an appropriate public policy aim. And he is going to choose, in the first administration, he was, not entirely, but there are a lot of people around him who would have been regarded as well qualified in traditional ways and had allegiance to kind of a certain set of institutional norms that would transcend individual administrations. Those people have all come out against his reelection. And if President Trump is reelected, he is not going to make the mistake of staffing up with people he thinks have any of those allegiances. So this is very worrisome. And I would just say, pardon me if I'm rambling too much, but the number one issue for me, or a number one issue for me, is how he speaks continually of presidential control over the direction of criminal prosecution in the Justice Department. Going back to Watergate, there has been a concerted institutional effort under both Democratic and Republican administrations to keep the White House at arm's length from prosecutorial decision-making in individual cases. Presidents, may say, I want you to worry, more about organized crime. I want you to worry more about drug crime. I want you to emphasize this kind of thing more than that. But you do not have presidents communicating. You certainly don't have presidential staff saying to the Justice Department, we want someone, we want John Smith, we want Jill Doe prosecuted. That's considered absolutely scandalous. And again, going back to former Attorney General Barr, who, despite his criticisms of Trump's behavior on January 6th, is a full-throated unitary executive person. He argued before he became Attorney General that presidents cannot constitutionally be excluded from the control of decision-making with regard to individual prosecutions, even involving his own family and associates. That is just a frightening view of the law.
And we have debates in Westminster systems about the role of politicians and the role of the Attorney General in particular, and that's a hotly contested area. And certainly when it comes to any semblance of political interference in the prosecutorial process, that's something that's generally regarded very dimly. I want to take you back to the first point that the first theme of the book or area of the book that you discussed, which was what the founders thought about executive power. But I want to just to talk through a little bit the constitutional clauses that unitary executive theorists rely on. What is in this famous Article 2 that President Trump trumpets? And you say there's the vesting clause, and then there's the faithful execution clause. And if you could just explain a little bit what the text of the Constitution says, and then I found the discussion in your book of the implied limits on particularly the vesting clause to be very persuasive, and so I suppose the text and then put in context would be helpful in terms of understanding how it is that unitary executive theorists think the way they do, but also why that is not as tenable as it might seem at first sight.
Sure. So, as I mentioned, the two clauses that are deemed most impactful in terms of assuring that presidents get this comprehensive discretionary role over the executive branch are the opening clause, the vesting clause. It just says the executive power shall be vested in a president of the United States. And it is thought to be, highly significant that it's vested in a president of the United States. And a premise of how this is read, which goes back to a dissent that the late Justice Scalia wrote in the 1980s opinion, is that the vesting of executive power is intended to mean the executive of all executive power, that there can be no other distribution of executive power. Now, there are a couple of problems with this just on the face of the Constitution. One is that the drafters of the Constitution had heard of the word all. It shows up in a lot of places in the Constitution. Congress is given the power to make all laws necessary and proper to carry into execution not only the powers that they have enumerated in the Constitution, but the powers vested by the Constitution in the government of the United States or any department thereof. And by department, they meant branch. So Congress would have the power to make laws necessary and proper for carrying out the powers of the executive branch, all laws necessary and proper for carrying out the powers of the executive branch and of the judiciary. So that right there suggests that maybe the omission of the word all is relevant to our textual understanding. The other clause that comes into play is a clause that sounds more like a requirement or a duty than a power. It is the obligation to take care that the laws be faithfully executed. In my own work, I tend to call this the faithful execution clause, but it's often called the take care clause. And I believe that the clause properly interpreted was intended chiefly to be understood as a ban on the executive suspension of statutes. that the president could not decide that there was a law that the legislature had enacted that, like, an English monarch, he could just say, "Nah, I'm not doing that." Now, the fact for him to be able to take care that the laws be faithfully executed, it has been argued that he functionally has to have some supervisory control over other parts of the executive branch. And clearly, over the centuries, the take care clause has come to be seen as a source of some supervisory authority. And just to show, there is not unitary executive theory comes in kind of different stripes, and there are different arguments that have been made. There are some who rely very heavily just on the vesting clause as encompassing basically all forms of royal prerogative that the Constitution itself does not explicitly take away. But Michael McConnell, who's a conservative constitutional theorist at Stanford, a very prominent, thoughtful person, has argued that whatever the executive branch gets through the vesting clause is defeasible in the sense that it can be regulated by Congress. But he reads Article 2 as including, this sort of very broad but defeasible executive power in the vesting clause, followed by more specific powers, including the take care, what he would call the take care power. And so he wants to rely on the take care clause because he thinks that powers that flow from the take care clause are not defeasible. They're not regulable by the legislature. So that, as we say, this slices the bologna very thin. It just, it tries to look in a very granular way. And of course, the argument that this all that's sort of lurking behind here is an argument over the president's removal power. What does this guarantee in terms of the president's ability to remove at will officers of the United States? Well, the first thing you notice as a textualist is that there's nothing in Article 2 about removal. And if this power was deemed so central to the operation of the executive branch as the framers intended it, you would have expected it also to have been debated in Philadelphia and to have played some prominent role in the ratification debates in the individual states. Nope. There's virtually no such debate. So unless you have the proposition that, as soon as the words executive power are mentioned, people are just going to have the common understanding that that means whoever's in charge can fire everybody in the executive establishment at their own discretion. Unless you think that there's a basis for that kind of consensus understanding, this whole idea that that's the original public meaning just falls apart. Now, the other thing about Article 2 is it does have other things that the president can do. And one of the things that the president is allowed to do, empowered to do, is he is empowered to, and I mentioned this before, ask for the opinions in writing of the heads of departments regarding the duties with which they've been vested by law. Now, just think for a moment, if the thesis of what the executive power vesting clause was accurate, that it was this huge comprehensive power of supervision, why would you need, as a framer, as a drafter, to spell out an entitlement of the president to ask his subordinates how they were discharging their tasks? I mean, if any power were be plainly implicit in a general power of supervision, it's the power to ask the people you're supervising to tell you what they're doing. So there must have been, I think, thought to be some relationship between the offices, and there are no executive offices created in the Constitution other than the president and vice president. These offices are going to be created by Congress. The heads of departments, these are going to be the heads of what we would now call agencies that Congress has created. The president's going to have a relationship to them to be sure, but they're also going to have an obligation of their own to follow the law and an obligation to fulfill duties that have been delegated to them by Congress. And to take all of that as just being, well, they're really just the president's helpers, just seems to be an implausible reading of the text. Putting aside, everything else about, what the founding generation saw going on in the states with regard to what governors were allowed to do, how law was being enforced, and so forth.
That's my next question, really. So the text of the Constitution is the U.S. Constitution is fairly succinct as to the role that the president would play. You make a very persuasive case, I would say, that the presidency at the time of the founding was not understood to be the major office of state. If anything, the main repository of power was going to be Congress. And there was a lot of concern at the time of the founding that Congress would have too much power. But what has happened, of course, is that the presidency has evolved, as things often do, especially in common law systems. And what's striking, and perhaps I've missed some literature from the 18th and 19th and early 20th century, the scholarship about a unitary executive theory really only starts to emerge in the latter half of the 20th century, after the presidency itself begins to take on its imperial character, to use the phrase of Arthur Schlesinger, his famous book. So what's going on there exactly? Is it that legal scholarship is catching up to political reality, and then is in turn enabling the features of this political reality and allowing them to become entrenched? Is that's what's happening here?
So in thinking about constitutional theories of the presidency, I suppose I find myself significantly influenced by the view of the political development of the institution of the presidency that emanates from the work of Stephen Skowronek at Yale. And Professor Skowronek, first of all, says that presidents have come to inhabit two positions, as it were, that are in kind of inevitable tension. They are, particularly the modern president is understood to be a political leader, a dynamic force, a disruptor, if you will, the person who has made bold promises that are going to be kept, but also the administrative chief, the chief of a stable administration that is obliged faithfully to execute the laws that have been made before this president got there, and which are nonetheless required to endure. So if you think about the presidency in 1789, the people who, well, I should perhaps back up one sentence and say, one of the issues that we have in terms of thinking about the presidency in 1789 terms, and Article 2 is, a lot more elliptical and Delphic than the article about the legislature, because they were creating something new. And the framers had much clearer ideas about what they didn't want than what they did want. The way in which the presidency unfolded in its early years reflected a much more kind of pragmatic, experimental attitude than you would gather from the way the framers are talked about by, my contemporary originalists. So for this moment, when George Washington is sitting in front of the room, someone of, widely admired character, someone who is not going to use the presidency as a vehicle for personal enrichment and aggrandizement. There is a thought that you could have a world in which policy is pretty much made by the legislature. It's implemented in day-to-day terms by an executive workforce of some kind that would be supervised by a kind of chief manager. And what you want in a manager is good judgment, good character, a track record of selfless accomplishment in public service. What you want is George Washington. You wouldn't want political parties. What they knew of political parties they didn't like. They tried to create a system that they thought would not be hospitable to political parties. And of course, that vision didn't last past the first Congress. You had caucuses in the very first Congress that became kind of the fetuses of what became what was called the Federalist Party and the Democratic Republican Party eventually. So party government, broke out. And once that happened, you had a tension that had to be resolved between a view of the executive bureaucracy as being this kind of having a kind of aristocratic caste. This would be people staffed by persons of gentlemanly character, and I'm not using gendered language accidentally. These would be persons of gentlemanly character doing their duties faithfully under the careful management of this chief manager. And of course, indeed, Hamilton talked about the civil service in the Federalist Papers as people who would remain in office from administration to administration. So with the outbreak of partisan politics, that became not sustainable. And by the early 19th century, or the first quarter of the 19th century, you see the first, what we think of as populist presidency in the presidency of Andrew Jackson. And the civil service now becomes, again, an instrument of party politics. It wasn't so much an instrument of the person of the president, because the control in political parties often rested at the state and local level. But the president still had to, appoint a lot of people. He would be importuned by the political bosses at all these levels. And it got to the point where, by the 1880s, you have the president himself, James Garfield, who sadly was assassinated, and then followed by others, wanting to depoliticize at least part of the civil service so that they could have time to do something other than be responsive to these local political bosses and could take on a more active policymaking role in the White House. Now we've moved forward. What happens? You have presidents and executive power increasing after the Civil War. There are a number of presidents who are pretty lackluster, but with the Spanish-American War and into World War I, you start seeing the executive branch becoming much more powerful. What is to keep the president from being authoritarian in that context? Well, his political influence is being balanced against this relatively new establishment of so-called expert agencies. And now the public will has to be worked through a deliberative process that goes through these agencies, not just run through the White House. What happens by 1980 is that because of changes in campaign finance law as much as anything, the parties themselves become weaker, and there is much more. They much more become kind of instruments of the person at the top, and a lot of party energy is shifted from the state and local stage to the national stage. So that when we think of the Republican Party of 1980, you think of Ronald Reagan, even though there were 20-something Republican governors, there were hundreds and hundreds of other Republican officers, but you focus on the president. In 1980, Congress, there seemed to be, there were reasons to think that the Republicans would be more successful over time in holding the presidency than any other institution of government. Our electoral college system is kind of weighted in the favor of what we call the red states, the more conservative states. And President Reagan and Republican presidents before him seemed to have put together a coalition that could keep Republicans in charge of the executive branch. There didn't seem much hope that that would happen in Congress. There was no plausible story for how the Republicans were going to take over the House of Representatives, and indeed that didn't happen for another 14 years. The Republicans hadn't controlled the House of Representatives since, I think, the Truman administration, or maybe the early Eisenhower administration. They did get back the Senate in the 1980 election, but again, because of the bicameral system, the Senate by itself just can't accomplish very much. So I do think for conservative activists at the time, thinking of the president as being powerful in the way envisioned by unitary executive theory was a way of positioning a conservative president to be able to jerk the public policy agenda of the federal government away from its more liberal, more moderate direction of the 1950s, 60s, and 70s towards in a more conservative direction. And the initial activists for originalism, the sort of obsession with not unitary executive theory, but originalism as a mode of constitutional interpretation, excuse me, didn't start in the academy. Give me 1 second just to.
Well, it started with Ronald Reagan's Attorney General, didn't it? Mr. Meese, famous speech that he gave really set the ball rolling in terms of originalism as a legal theory.
And even he was picking up on the work of other conservative activists in the 50s and 60s who saw originalism as a way of objecting to Brown versus Board of Education without saying we're opposing racial integration. Now, as we fast forward, as I say, there are a lot of scholars working on this, and I don't believe that I don't think of the leading scholars who are working in this area as being just, activists with tenure. I think, they're doing serious scholarship. There's a normative case that they offer for something, some version of originalism. The work I actually find most interesting in this regard is Keith Whittington's, who's recently gone from Princeton to Yale. So there are important arguments to be taken care of, and I think there are serious historians. But what's influencing the court is, in my judgment, not any of that, because when they get to the history part, the version of history that they're trotting out is the 1980 Republican platform. It's not serious history.
Law office history, we might say. One thing, my colleague Steve Chaplin asked a question about the relationship between congressional dysfunction and increased executive power. But what you were, and I'll ask you about that. I mean, whether the fact that Congress is so often gridlocked on questions of policy, it's a commonly expressed view that this means that presidents exercise more policy-making power through executive order and such like. But I was struck by something you said in your response to the last question about the weakening of political parties from the 1980s. And I wonder, and perhaps this is outside the scope of the book, but I think it's interesting nonetheless, to what extent are the weaknesses of political parties and the fact that the president now dominates the political parties, and increasingly so in the case of President Trump, to what extent does that contribute to dysfunction in Congress and polarization in Congress and in the community more broadly?
Yeah, I think the answer is considerable. And just sort of to take apart kind of the two big issues you're raising, the dysfunction of Congress and what's happening with political parties, there's no doubt that Congress's inability to muster sufficient votes for the proposition that the sun rises in the east does create a kind of power vacuum. As friends of mine often remind me, presidents are not elected to do nothing. They're elected for something to happen, and they're going to find ways to try to make it happen. There is an interesting difference and this I think reflects a kind of philosophical difference, but also a kind of difference in organizational psychology between, I would say, recent Republican administrations and recent Democratic administrations. Republican administrations have adopted unitary executive theory. They believe that the president has very broad discretion to do things by virtue of what the Constitution guarantees in terms of the president's role. Democratic presidents are much slower to make those claims. In the world of war powers, maybe yes. In fact, there's an argument to be made that Democratic administrations are even more aggressive in interpreting presidential war power than recent Republican administrations. But in terms of domestic policymaking, the move that is customarily made by a Democratic president is to interpret statutory language broadly. And so you will see administrative agencies within a Democratic administration using broad statutory language to justify regulatory initiatives, other kinds of initiative that will carry out the kind of agenda that the president ran on. And Congress, it's bad that they're unable. Well, they're unable, except in very particular circumstances, to legislate meaningfully. There has to be, and there have been some exceptions to this, but right now, each party is, can become so concerned with what the other party can take credit for that the most obvious compromises that are available are just not being made. You can think back to 2009 and 2010 when Congress was debating about Obama's healthcare proposals. Obama's healthcare proposals got through only because of the size of the Senate majority for the Democrats at the time and the strategic sophistication of Nancy Pelosi as Speaker of the House. Even though that, like it or not like it, the Affordable Care Act is based on ideas that came from conservative think tanks. This is what Mitt Romney was doing in Massachusetts. And the thought was, hey, we're taking your policies, surely we're going to get your support. No. Right now, the Republicans in the House, which they govern by a very thin majority, were able to use their leverage to empower the Republican minority in the Senate to extract from the Democrats the toughest immigration policy ever written into modern immigration law in the United States. That would be written into immigration law in the United States. There is a deal no other Democratic majority would have gone for, or any Democratic president would sign. And then Donald Trump said, don't vote for this, because this is going to give Biden an achievement to run on in November of 2024. And the members of the House, including members who themselves were narrowly elected in districts that Biden won in 2020, are going along with this. If this bargain actually got to the floor of the House, it would have a majority if people could vote on it. But people are afraid to say no to Trump. Now, what's happened with regard to the parties is, I think, a product of two things. One is we now have a system of fundraising where every member of Congress, every member of the Senate is kind of an individual fundraising entrepreneur. Again, there's a very detailed version of this, but let's just say that everybody's got their own fundraising thing. It's their dominant activity. And so the party, has much less control that way than it did over its membership. But also, my friend and colleague, Rick Pildes, who is, I think of as being one of the founders of what we call the law of democracy studies in the US, has said, the biggest change in the presidency over the last 50 years is what has happened in the selection of candidates through the primary system. And it is the primary system that has really taken the selection of presidential candidates away from the parties and put it in the hands of voters who are being approached by well-funded individual campaigns. Right now, the Republican National Committee, the chief committee of the Republican Party at the national level, has been chaired for the last, 9 years or something like that, by I believe that I think she's the daughter-in-law or niece of Mitt Romney, who has tried very hard to kowtow as much as possible to Trump, but he's not been happy with it. And he was not happy with the fact that the RNC allowed presidential debates to occur without him present. They weren't excluding him. He just didn't want the debates to happen. So he now is going to have, she's resigned under pressure. He is pushing for the appointment of a loyalist, from one of the states, a guy who, has joined him in saying that Biden actually lost the 2020 election. And he wants as co-chair his daughter-in-law. I mean, he just wants the National Party Committee to be an arm of his personal fundraising. And this is, this would be unrecognizable to party leaders, before 1970.
It is quite extraordinary. I'm going to ask you, we got about 10, 15 minutes left. And so I want to try and get you to be optimistic. And you advocate what you call democratic constitutionalism as a way of rethinking the presidency and the nature and scope of presidential power in the United States. And there are two aspects to that, I think. One is the rule of law, and the other is deliberation, the value of deliberative democracy and thinking things through and arguing about them. What I, if I may say, thought was striking about how you presented these values is that you identify them as fairly deep-seated, deep-rooted features of the American constitutional order. So you're not an originalist, but nonetheless you draw heavily on history and tradition in relation to the rule of law and deliberation as devices for rethinking the presidency.
Yes. So when I say that I'm not an originalist, I don't mean to say that I think history is irrelevant. I don't mean that at all. And the originalism that I object to, as I think I started to say, is this highly formalist view of originalism, in which we think about what counts from an earlier generation only in very narrow linguistic terms. I do think some of the problems that we're encounter today are problems that would have resonated in the public lives of the founding generation and subsequent generations, and thinking about how other smart, well-intentioned people address those problems is often instructive. We may not be concerned today. Right. We're not concerned today that the United States is going to be overrun by a Navy comprising, tall masted wooden ships, but we're still worried about national defense. And we can think about, in the context of, let's say, interpreting the impeachment clauses. We're still worried about corruption. So one debate that came up, and I discussed this a bit in the book, that came up with regard to, well, the Clinton impeachment and the Trump impeachments, is whether the phrase high crimes and misdemeanors, the grounds for impeachment, include only things that would also be crimes under the Federal Criminal Code. Or should the clause be interpreted to basically allow for impeachments based upon gross abuses of power that are not unlawful, that is, are not in violation of the criminal code. Now, if you look at that from an originalist perspective, again, we could talk about this at greater length, but I think the case is pretty strong that the founding generation, I shouldn't be too much, but I think the case is compelling that the founding generation did not think that high crimes and misdemeanors would be limited to technical felonies. They thought about it as a broader class of gross political abuses of office. Now, do I think that we should feel obligated in some normative way to think about the clause in that way because that's what they thought in 1789? No. But what I do think is what led them to that view was a concern about corruption that is every bit as pressing in contemporary America as it was then. And having thought about the reasons for wanting to have a broad view of what high crimes and misdemeanors would be, those reasons still make sense in terms of maintaining a presidency accountable to the rule of law. So can we learn something from their debates, their concerns? Of course. But we should understand we're making the decision. They haven't made the decision for us. They've left us their legacy. We can interpret it, we can draw from it, but it's our decision. And what we have to decide is the degree to which our concerns resemble and the context resembles their context, and we ought to be educated by it. And by the way, if you're looking for any other bit of optimism, I believe that there's nothing to the rumor that even in a second Trump administration, there'll be a wall built between the United States and Canada. I think I'm willing to go on record with that prediction.
Yes, though I don't think you should be.
Canadians might not regard that as optimism, but
I don't think you should expect a flow of people in that direction over the border. It would be probably a wall that would be keeping some Americans, some liberty-minded Americans out or in, rather than keeping Canadians out. So Martha McDougall asked a question, and this again is in a different register. It's about January 6th, and I noticed that you recently put a paper on SSRN on the litigation about President Trump's eligibility to be on the ballot for the Colorado primary and potentially on the ballot in the general election. The Supreme Court heard argument in this case earlier this month. I think most observers listening to that have concluded that the Supreme Court will find some way, anyway, to ensure that President Trump's name is on the ballot. You suggest that your paper is entitled "The Least Harmful Way to Leave Trump on the Ballot." Do you anything you want to say about that case? Why the Supreme Court is going to go is likely to find for Trump, and what sort of damage mitigation should we be hoping for when we get the ruling? Probably not very long from now.
Yeah. So I do think because of how controversial was the role of the Supreme Court in Bush versus Gore and effectively deciding the outcome of the election in the year 2000, I think this court is very much going to not want to seem responsible for doing something impactful in quite the same way. I don't think that they can get out of it entirely. Whatever they decide, they're going to be criticized for it one way or the other. But it was a conspicuous feature of the argument that they devoted very little attention to what Section 3 of the 14th Amendment actually meant in terms of disqualifying, an insurrectionist former office holder from the presidency, and they were looking for, ways not to get there. What I argued in the paper was that the least damaging way to leave Trump on the ballot would be to find that the 14th Amendment required, with regard to a national figure, the president or the vice president, that Congress adopt a process by which the states could be involved, that states would not be doing this on their own. Because I do want the 14th Amendment. First of all, I don't want them to say that presidents are not covered by it. I don't want them to say that Congress needs to legislate before some office holder in this who has attacked the Capitol on January 6th now wants to run for a state office. I don't think they should be allowed to do that. And I think individual states can do that, but I think the implications for national elections are just too complicated. Since writing that paper, I've actually come to think that Congress, in a way, might have already written this statute. And again, this can get pretty into the weedsy pretty quickly. But after what happened on January 6th of 2021, Congress, in a rare moment of bipartisan, serious, substantive political engagement, enacted something called the Electoral Count Reform Act. The main point of which was to make what happens on January 6th much more obviously a ministerial set of acts and much less, monkey business going on that could, displace the will of the voters. Now, in that statute, they did something interesting, which is, and again, the Electoral College is our least successful constitutional export. Nobody wants it. We ought to get rid of it. But while we have it, we basically have 51 separate elections for electors from every state and the District of Columbia. And those electors get chosen on election day. And then there's a process by which they get certified, and the certification of a certified slate gets sent to Congress, and those votes get counted. Between the electors being chosen on election day in November and the day they actually cast electoral votes in December, is a kind of 6-week interval. And what the statute allows is for, in any particular state, if there are legal challenges to be made against the certification of the apparently victorious electors, that a presidential campaign, presumably the losing presidential campaign, can raise that issue in a lawsuit that would be brought in a federal court, a 3-judge court that would decide the issue, and depending on the outcome, it could be appealed as of right expeditiously to the Supreme Court. Put aside, the insurrectionist issue. Imagine that you had the electors in a state who are pledged to, elect Taylor Swift, and Ms. Swift, who's a wonderful force for good, is not 35, so she's not qualified to be president. And you could imagine the party that lost to Taylor Swift bringing a lawsuit after election day that says, look, the electors who are pledged to Taylor Swift can't be certified because they're being pledged to a candidate who is not allowed to be president given the Constitution of the United States. That is a process that could be used to disqualify electors who are pledged to Trump based on his being an insurrectionist. Now, I want to say this is a scary prospect. If Trump?
Not very comforting. No. So this would
No.
be after a Trump victory in the election. But perhaps he loses the popular vote but wins the Electoral College. So potentially a very tense situation. Then
Right.
you could have court challenges to his to electors casting their votes for him as members of the Electoral College on the basis that he engaged in an insurrection on January 6th.
But I wouldn't say you could have litigation. I think you will have litigation. Now, the alternative to that, I mean, that's scary. Here's what's scarier, that there's no court looking at this issue before January 6th of 2025. The Electoral Council always counted on the 6th day of January after the election day. So if 1/5 of the House or 1/5 of the Senate agrees that some electors pledged to one of the candidates are basically have cast their ballots for somebody constitutionally unqualified, they can raise an objection. And however great the threat of violence and discord might be, if a court got involved after election day but before December, the threat of that happening, if this is pushed onto Congress on January 6th, I think would be exponentially greater. And to be honest, I am worried for the solidity of our social fabric after the next election day. I'm sure, I think the candidates are going to be President Biden and former President Trump. I think if President Biden wins the Electoral College, that President Trump will again say he didn't. And if President Trump wins the Electoral College, I think we're in for a very rough time.
Well, on that happy note, Professor Peter Shane, it was a pleasure to have you on. We've been discussing, for the most part, your book, Democracy's Chief Executive. There's the cover, interpreting the Constitution and defining the future of the presidency. A very interesting and thought-provoking take, as you say, on the founders and what they thought of the presidency, originalism, and the emergence of unitary executive theory, but with also your own approach to redefining the presidency and defining its future in a more positive way. So thank you very much for having been with us, and we can only wish you good fortitude as we head towards election day in November and all of the legal controversies that might entail. Thank you very much, Professor Shane.
Oh, thank you for having me. It's a real privilege.